The court will now take up the case of the state of Florida versus Garcia. Counsel.
Mr. Chief Justice, and may it please the court, this case presents an important question of constitutional criminal procedure, but it's ultimately not the right case to resolve that question for the simple fact that Mr. Garcia has not established that he has irreparable harm. So I'd like to start this morning by explaining why the district court lacked jurisdiction, and I'll do so in two main parts. First, Mr. Garcia hasn't suffered any Fifth Amendment injury at all. That would happen only if he went to trial and were convicted on the strength of compelled testimony. Which
let me ask you about a little different scenario in response to that point. What if this had gone a step further, and Mr. And correct me if I'm wrong, and this has already happened, but Mr. Garcia had been held in contempt and put in jail for the contempt for failing to follow the trial court's directive to produce the code. Would he have no remedy for that?
He could take an immediate appeal of that contempt conviction and sentence. And so that remedy is, of course, available to him. But
so that would basically be an appeal of a final order.
Yes.
And but the underlying question of the validity of the trial court's order would be at issue there and would be resolvable there.
I believe so, Chief Justice Kennedy, and that's certainly a route that he could travel to get relief here.
And that if you win, that might be the next step, right?
That may well be the next step, or he may opt to reveal the passcode, and if we ultimately convict him based on the strength of whatever testimony and its fruits we obtain during our execution of the search warrant, he would of course have the option to direct appeal and raise all of the same Fifth Amendment merits claims that he raises now.
Sort of pregnant in that is a concession, I think, right? Are you admitting then that if it came to us in the context of contempt proceedings, the Fifth Amendment right would have attached, even though there is no, in fact, trial, that there's no jury, there's no attachment of jeopardy, a contempt finding would have triggered the applicability of a Fifth Amendment testimonial concern. Is that accurate?
Justice Couriel, we say, and this is the Gekas decision from the en banc 11th Circuit, that what he has invoked here is the prophylactic protection of the right, but not the core protection of the right, which is the protection against being convicted at trial based on compelled testimony. So he, of course, has the right to invoke if, in fact, there would be Fifth Amendment compelled testimony. But our basic point, at least on this first prong of irreparable injury, is that he hasn't suffered an injury one way or the other. That will happen only at trial. But we're not saying that if he were right about the merits, he wouldn't be able to invoke here. We think that he would be able to.
Is it Florida law in a context of civil cases that someone can invoke their Fifth Amendment and then have that review by cert because it will present irreparable harm?
So it's true that there are some district court decisions that are out there in the civil deposition or subpoena context. We haven't taken a position in this case on whether those cases are rightly decided, and we don't think that the court needs to get to it.
Wouldn't your position necessarily determine that those are error as a matter of law?
I don't think so, Justice Paulson. There might be. So first of all, the cases that you're referring to don't clearly articulate a theory of irreparable harm. Many of them don't even discuss it. They simply assume that there's irreparable harm. But there may be, and again, you don't have to get to this question, but there may be theories that would support the idea that that's irreparable harm. The 11th Circuit has some case law, Handley and White, which say that when you are compelled by a private litigant in a civil case to testify, that is not government compulsion. And so the 11th Circuit's case law perhaps raises the specter that the defendant there wouldn't be able to suppress that testimony in a subsequent prosecution. Now, I'm not sure that that's right or that's how this court would come out on the question.
I don't understand why that should be different in a civil and criminal context, because if you're in a civil context, at the heart of the matter, you're afraid of being prosecuted for something that's going to be divulged in that material, right? So it seems like you would be more concerned in a criminal proceeding than you even would be in a civil.
Well, so the distinction I'm trying to draw, Justice Paulson, between the civil cases and the criminal cases that the 11th Circuit has drawn is that perhaps if you're compelled in the civil case, there's been no governmental compulsion. There's no state actor that's compelling you, and thus that testimony and its fruits could be used in the subsequent criminal prosecution. That's not true in the criminal context because it would be the state that would be doing the compulsion. And so the fruit of the poisonous tree doctrine would attach here, and we wouldn't be able to use those fruits against him at trial. But I mean, again, I think that's a much more complicated and nuanced question, one that's not in front of the court.
Well, it seems pretty pertinent to me, at least.
Well, all our submission is that there may be justifications for that line of district court decisions.
Because it goes to irreparable harm. It seems like, I mean, if you say there's irreparable harm in a civil context, why wouldn't there be here?
I think it goes to the point about whether or not there's government compulsion in the civil context.
And so on that point, though, I mean, for us to say that there's no harm here, irreparable harm, does that mean that we have to say that essentially that the compulsion standing alone is not a problem, that there's really no problem for Fifth Amendment purposes until it's actually used against you and it actually matters?
That's exactly right. I mean,
and I understand, I understand in the abstract that argument, but I mean, it doesn't seem like and maybe it's this whole distinction between the prophylactic thing and the actual substantive prohibition, but it seems like it kind of goes against the grain of our system in general to say we're indifferent to the compulsion at this stage. We really only are going to care about it and deem it harm if you end up being convicted of this test.
So Justice Muniz, the Castigar case, I do think stands for this idea that the compulsion itself is not the Fifth Amendment injury. That has to be the rule that comes out of Castigar, because Castigar says the government can compel you. In the abstract, there's nothing wrong with that, so long as it immunizes you, meaning it can't harm you at trial by introducing the statements. So there's no abstract dignitary or privacy interest at stake that the Fifth Amendment protects. We can compel you. That's not the problem.
But if it turns out, though, that it was wrong to have compelled, and I know you haven't gotten to the merits yet, but if you were compelled on the basis of a sort of a legal error as to whether this was all that, then that really is harm that cannot be undone. I mean, in terms of the conviction, but so basically it gets back to the compulsion itself just isn't harm that the law recognizes.
Right. Of course, there's a mountain of U.S. Supreme Court case law that indicates just that: Patain, Chavez, Castigar, and of course the en banc 11th Circuit in Gekas. But one way or the other, we know that the fruit of the poisonous tree doctrine would apply to any compelled statements that he may utter, and so anything after that point would be tainted. If there is, in fact, a Fifth Amendment violation when we compel the passcode that enables us to get into the phone to search it, any physical fruits we find will be tainted. And so his remedy, ultimately, is that, number one, he could move to suppress at trial on this theory that that hasn't happened yet. We don't know if we will find any fruits. And of course, if he's convicted and sentenced, he can always appeal. I mean, this is the basic structure that our system creates for criminal defendants when they believe that they've been harmed in some way. So defendants could say any number of things would harm them in the sense that they'll be convicted. So erroneously introduced hearsay evidence or Williams rule, collateral crimes evidence, any of that could be harmful at trial and could lead to a conviction, but you don't have the right to seek cert pre-trial. That's Pettis, which says that criminal defendants have no right to an interlocutory appeal.
Can I ask you a merits-related question?
Of course.
So does it matter, is this teed up in a way that if we did get to the merits that we could draw this distinction between someone entering the passcode where the government never actually learns what it is, and so you really only do have this testimonial aspect of knowledge and confirming that it's my phone? Given that here what was asked for and what the DCA wrote about was actually disclosing the code itself.
So our first position here, which is that this is just not testimonial to begin with, I think that you could resolve that question here on the basis that within the original meaning of the Fifth Amendment, a grant of access so that law enforcement could execute a warrant is just categorically not testimonial. Now, maybe more directly to your point, perhaps you think that there is some difference between being required to disclose your passcode and being required to enter it. We think that as a functional matter, there really is no difference. The government in this case doesn't care what the contents of the passcode are. That's not useful to us in any way, except that it's a grant of access. So it's not that we care about...
Isn't it demonstrative of ownership and possession at the crime scene?
Yeah, so, right. And that goes to the active production doctrine, but I understood Justice Muniz's question to suggest that there is some difference for the purpose of this inquiry between disclosing your passcode and being forced to enter it. But to your point, either of those things involve an act of production. There is still an implicit testimony conveyed when he either inputs it or gives it to us. He's saying, I have access to the passcode, I know what it is, and that the passcode exists. Of course, under the foregone conclusion doctrine, we know all of those things. And
You don't know the passcode. I'm just wondering, I mean, it's arguable that the foregone conclusion thing just categorically doesn't apply to the actual passcode. It does apply to these other things that you can infer from the fact that he knows the passcode. And so I was curious about that. I mean, because you suggest, in your brief, you say, well, and it would be less convenient for us, but if he has to just enter the passcode, then that's fine. And I'm just wondering if the court were inclined to kind of take that off ramp, if that's even procedurally sort of an option for us.
So, Justice Muniz, if it was the court's view that there was simply a defect in the form of what the state asked for here, we would take that ruling. I think that's a win for us, because on remand we could simply ask for the right thing. But I think that helps to make the point that, functionally speaking, there's no difference for the purposes that Mr. Garcia is concerned about, which is the act of production. There's no difference if he's required to disclose the passcode, which says that he knows it, or if he's required to manually enter it, which again shows that he knows it, or if he's required to put his thumbprint on the phone to unlock the device with biometrics, which of course would show that it's in fact his phone. So for all the reasons that he cares about, which is this alleged act of production, it all boils down to the same thing. But, I mean, of course, if the court's holding is that there's a problem in what we asked for, that seems to me could be remedied below. So I do want to talk about our threshold theory that this is just not testimonial in the first place. And maybe the plainest way to think about that is that if at the time of the framing, a constable was armed with a warrant to search a home and showed up at the suspect's home, there would have been nothing that the suspect could have done to turn away the law enforcement officer. He had a warrant signed by a magistrate that authorized the search and in fact ordered the law enforcement officer to go and search. And so the constable could have done either of two things. Number one, under Payton versus New York, the U.S. Supreme Court said that it would have been constitutionally reasonable for him to require the suspect to unlock his doors. So the officer could have actually demanded entry and been given entry that way. And second, even barring that, the officer simply could have broken down the door. There were no doors at the time that couldn't have been broken and then entered by law enforcement. So the point is, warrants have always equaled access. And we don't think that changes in technology have changed that basic reality. And it would have been, I think, quite absurd for the constable to have showed up at the home, demanded entry, and for the suspect to have purported to invoke his Fifth Amendment right. No one would have thought that the Fifth Amendment had anything at all to say about this question, which is really a question about search and seizure. And
on access, I think one of the briefs actually raised a question whether you really need the passcode or not to get into the contents of the phone. Is it your position that, yes, you really need the passcode, or can you get it in other means?
So I'll say number one, I don't think that our theory of this being non-testimonial turns on that. We may not have needed the suspect to open the door for us at the framing, but we still could have compelled that. So I think one way or the other, this might be a collateral point. But number two...
So you may not need the passcode, but you still want it?
It appeared... Well, there may be some cases where we could get into the phone. The record here says that we could not and that we tried to do a forensic download. More broadly, there's been some debate about whether technology out there allows us to decrypt phones. What I can tell you based on our conversations with FDLE, this is my understanding, there are really two camps of devices that we might try to get into that could be encrypted. The first would be hard drives, laptops, computers. FDLE says it can be nearly impossible to crack those if they receive the device with the basic encryption that ships from the factory enabled. It can be almost impossible. The second camp, of course, is what's at issue here, cell phones, although I think your ruling will apply across the board. With cell phones, the case is a little bit better for us. There are some devices that we can get into. It depends on whether these technology companies, Celebrite and Grayshift, have been able to crack those devices. Newer devices, it's much harder, and it may even matter the state that the phone comes in. So that's perhaps a technical answer, but it looks like even now there will be many devices we can't get into. However, even more generally, what Professor Kerr says is that this is an arms race between encryption and decryption, and encryption over time is likely to ultimately prevail because of the mathematics here. So even if tomorrow we had the technology to get into Mr. Garcia's phone, a month from now, the software companies might send out an operating system update, which would divest us of that ability.
So on your point, though, about it not being testimony, it seems like both the courts and the academics who agree with on your ultimate position on the merits say that they do think that it is testimonial. And is there a good authority on the other side in this? I'm not just by analogy to letting someone into your house, but what's the best authority looking at this specific question that just says at the threshold it's not testimonial at all?
So the Stahl case comes close, although at the end of the day it still applies the foregone conclusion doctrine. So I don't quite think it's in our corner there. The fact of the matter is, Justice Muniz, the theory that we've advanced of this being simply non-testimonial at the gate is a theory that hasn't been adopted by any court. I don't know that it's been advanced in any court. So it is a little bit something new as far as the doctrine that's out there. As far as U.S. Supreme Court cases that, none of them are on point, but there are some that are useful guidance. I think that the Doe 2 case comes very close as far as physical analogs go. So what happens in Doe 2 is that the government learns that Doe has foreign bank accounts, and the government, of course, can't get in unless it has a signed consent agreement from Doe. And so it asks him to fill out this consent form, which requires his signature. And of course, if the signature doesn't match whatever signature the bank has on file, the bank's not going to let the government in. And so it needs the signature to be accurate. And of course, a signature uses the contents of the mind. And what the Supreme Court said there was that wasn't testimonial. That is just signing a piece of paper that's more or less equivocal that has, as an incident to the signature, a grant of access. That's what we think is happening here. So the passcode here is more or less the same as the signature. If it's not accurate, then access isn't granted, and the court says, well, that's okay. That's not testimonial. So what we're asking for is maybe something a little bit different from what the other courts have done, but I still think we're on firm footing. And I'd go back to the House analogy because I think it's a potent one. Again, he has no right in 1791 to say, I'm not letting you in because of my Fifth Amendment privilege.
I can't remember if it's Doe 1 or Doe 2, where there's the discussion about comparing access to a combination for a safe,
Right.
as opposed to a key. I think that's the comparison.
Right.
They were saying what they authorized there, they thought was more like a key than the combination to a safe. Am I remembering that correctly?
Yes. So
doesn't that now maybe that's dicta, whatever, but doesn't that kind of cut against you here?
Well, I'm not sure. In the context of Doe 2, where the analogy was first used, the court, I think, believed that the signature was more like the key and thus was non-testimonial. Now,
but in the context there, doesn't it suggest that the requiring the combination to the safe would be problematic? No, they've essentially conceded that.
So two things about that, Chief Justice Kennedy. The first is that those are not cases. So that language appears in Hubble as well, in the majority opinion in Hubble. Those cases are not search warrant cases. And so our theory of this being non-testimonial turns on the existence of the search warrant. So number one, I think it's inapplicable for that reason. And number two, even in Hubble, I think it's dicta. It's a helpful analogy that the court relied on, but the court didn't purport to resolve that question. And so you can still decide whether you think that analogy makes sense in this context. And we think ultimately it doesn't, because for the reasons I was discussing with Justice Muniz, there's no practical, functional difference between revealing the passcode and being forced to manually unlock the phone.
Counsel, we have eaten up your rebuttal time here. I'm going to give you 3 additional minutes, but that's starting to run now. So
Thank you very much.
May it please the court. My name is Robert Adams. I am appearing on behalf of the respondent, Johnathan David Garcia. Your Honors, forcing a criminal defendant to disclose a passcode violates the Fifth Amendment because it compels the defendant to become a witness against himself. The Fifth DCA agreed with this proposition, and despite the state's arguments to the contrary, the Fifth DCA had jurisdiction to issue its writ of certiorari. The trial court's order did compel actual testimony from Mr. Garcia, to which the foregone conclusion exception has not been applied and should not be applied. And the foregone conclusion exception, if it were to be applied by the court, should require the state to demonstrate by a high burden at an evidentiary hearing before the trial court that what they're seeking, the testimonial value of what they're seeking actually is a foregone conclusion based on the information they already have. And that was not done below, so it cannot be applied here. Turning to the question of jurisdiction, petitioner claims that Mr. Garcia has not suffered any injury, will not suffer any injury from the compulsion order itself. This is not correct. The compulsion order does injure the defendant in the same way that Justice Polston suggested it would injure a civil litigant, that the district courts have accepted. The concept here of an irremediable harm, a harm that cannot be adequately remedied on appeal, is that if you were to compel a civil litigant to provide the answer to the question that supposedly brings about incriminating information, that civil litigant may be subjected to criminal prosecution that they're not currently facing. That's true even where the defendant is already facing some criminal prosecution, because if the compelled communication provides evidence of crimes to which the law enforcement does not know, they're now going to be facing further prosecution. For instance, in this case, we had the alleged victim come to law enforcement after the issuance of the arrest warrant and say, I found this GPS device in my car. I believe that Mr. Garcia planted it there.
But when is that injury suffered? Is it suffered when law enforcement learns of these additional facts, or when the prosecution happens and the trial rights attach?
It would be suffered when he's compelled to give the statement that gives law enforcement that knowledge to support bringing about the charge.
I guess my trouble with that is that it would seem like perhaps you're speaking about some privacy interests that you're saying sort of floats around the trial right, but I don't see in what Mr. D'Souza referred to as the mountain of Supreme Court case law any support for that proposition. I find instead support for the proposition that the injury is suffered when jeopardy attaches and evidence is introduced and the jury relies upon that evidence. Help me understand how this more attenuated interest or this different interest somehow attaches as soon as the law enforcement team learns what it learns.
Well, once they've learned that information, the mere fact that the litigant in a civil case or the defendant in a criminal case can be subjected to criminal prosecution they weren't previously facing would be itself a harm. It would put them.
I'm not sure I agree. Can you direct me to a case that says that the existence of that possibility is itself a harm as opposed to the prosecution?
Sure. There's the Aguila case from the 3rd DCA. There's also cases that were cited in both the initial brief and the answer brief, recognizing that these are the opinions of multiple district courts below. I don't think even the petitioner is disagreeing that those were the holdings of civil cases that compelling a civil litigant, normally in the context of a deposition, to provide what could be incriminating testimony in that deposition might open them up not only to the prospect of having to reveal privileged information, but to the prospect of having to reveal information about crimes that are not yet known. And while the petitioner claimed in the initial brief that those cases are an apposite to a case that involves a criminal defendant, we just don't see that to be true. It seems to be a distinction without a meaningful difference. Both of these people, the civil litigant and the criminal defendant, Mr. Garcia, are in that same position. Given how ubiquitous cell phones are with everyday life and how often they're used for things that would involve privileged communications, it's also entirely plausible that if a criminal defendant were to provide that kind of access by divulging the passcode, by giving that testimony, that they would also end up opening the door to privileged information as well, the same way that the civil litigant would when the DCA's decided that that civil litigant had a harm that could not be remedied on direct appeal, because once that cat is out of the bag, it can't be put back in. Once that bell is rung, it can't be unrung. So unfortunately, it creates a situation where if the DCAs are incorrect, up until the Foster case from the First District Court, then the litigant would be in the position of having to attest in their petition, or perhaps in a response to a motion to dismiss, as to what specifically the harm would be that they would face from being compelled to give this incriminating statement. And of course, that creates a paradoxical circumstance where the litigant is having to give some indicia of what the harm they will suffer is, give some indication of what new evidence of an unknown crime or what privileged information might actually exist in the contents of their statement, or by implication from the contents of their statement. And to do that would be to essentially say, well, in order to assert your Fifth Amendment right against compelled self-incrimination, you're going to have to do a little bit of self-incrimination so that we know that you're coming to us with a genuine article of harm.
What do you make of the fact that the amendment speaks of being a witness against yourself, right? It doesn't say of supplying information. It doesn't say of providing inferences. It says of being a witness, right?
That's true. Your Honor, for that, I would direct the court's attention to the Hubble case from the United States Supreme Court. That addresses, we believe, the state's argument that this is exclusively a trial right. We don't think that the United States Supreme Court agrees with that interpretation. And Justice Stevens' writing for the majority opinion said that the phrase "in any criminal case" in the text of the Fifth Amendment might have been read to limit its coverage to compel testimony that's used against the defendant in the trial itself. It has, however, long been settled that its protection encompasses compelled statements that lead to the discovery of incriminating evidence, even though the statements themselves are not incriminating and are not introduced into evidence. So it divorces this concept of the harm from a statement and the potential for violating the Fifth Amendment from the question of what actually ends up getting used at trial. And the fact that you're being forced to compel, or being forced to provide self-incriminating information or give a self-incriminating statement, even if it isn't ultimately used, is not the question. The question is whether or not that act in and of itself violates the Fifth Amendment. Now, it may not provide grounds for bringing a 1983 claim in federal court for damages, but it does create a violation that the DCA has seen as cognizable for a number of civil litigants, and for which there's no difference for a criminal defendant who's facing the same type of order.
Can I ask you, I'm sorry, I know that on the certiorari issues, most of the arguments have focused on the harm question, but isn't the other part of the test that the error has to be something where the law that was departed from by the trial court was clearly established? And it doesn't seem to me like this seems like the opposite of clearly established.
To that, our argument is that it is clearly established because it's clear from the meaning of the Fifth Amendment. It's clearly established because this circumstance clearly involves an order compelling Mr. Garcia to testify against himself. This isn't like the circumstances of Fisher or Doe and Doe 2. It's more like the concurring opinions suggestion of the difference between providing a combination to a lock versus a key. Based on those opinions, the essential requirements of the law would have compelled Judge Adams to look at the circumstances and say, you're asking state for the court to give an order that compels Mr. Garcia to reveal the contents of his mind, not to give you a key or unlock a cabinet like in the Fisher case and hand over a document inside the cabinet, but instead you're asking him to essentially reveal something that's only contained in his memory. And it's not a pre-existing document. You're asking him to create that testimony today, this afternoon, tomorrow morning. It happened to be tomorrow morning because Mr. Garcia wasn't present that day. But either way, whether it's we're going to show you the phone screen and you're going to type it in front of us, you're going to write it down, hand it to your attorney hands it to us, you speak it in open court, all of those still require the defendant to actually probe the contents of his mind, assuming he is the owner of the phone, and then reveal the contents of his mind. It relies on his truth-telling function, which is also a distinguishable element that's noted in the Fisher case, because if he gives the wrong passcode, he can face perjury. It's entirely possible that he could give the wrong passcode.
But how does this, you're talking about the contents of the mind, how does that fit in with the circumstance where there's, you can get in with your fingerprint? Fingerprint's not the contents of your mind, and it may be, maybe you don't even have to show them, you just give them your hand. and they, say which digit, they try the digits, and they get in that way. How does that, should that in principle be treated differently because it's not a revelation of the contents of someone's mind?
Yes, it should. And to be clear, there's a couple of problems with approaching this particular issue before the court on these circumstances with that analysis, because as both the petitioner and respondent have recognized, realistically speaking, the fingerprint probably won't provide access at this point. Most phones have a timeout lock that require you to use a passcode. So unfortunately, that wouldn't be an effective order, and we just end up coming right back around to seeking review from this court. The other problem with that is, if it were to be like a normal order for fingerprint exemplars, where the court is compelling the defendant to show up and place all 10 fingers on an ink pad and then place the inked fingers all on a piece of paper, and then all of those prints would be compared against whatever latent prints were pulled from a crime scene, that would not be testimonial. It's well established that's non-testimonial act of surrender or act of production. However, if the order were to say instead, use the finger that you used to lock this phone.
Yeah, but my question didn't ask about that. It was assuming that just give them the hands. And
Sure, if it
they
was
have
just-
to go through it one by one.
If it was
Or
identical,
maybe start with the thumb because that's maybe the most likely one.
and if it were identical to fingerprint exemplars, where it was just a process of elimination going through each finger, and he was just compelled, put this finger, put this finger, put this finger, without asking him to use the contents of his mind, that would absolutely be distinguishable. But it's not the same as being
What sense
required
does that make? I'm just trying to understand why, given the whole context here, that is not just a hyper-formalistic
It would be
way of looking at this.
Well, it would be distinguishable in the sense that because it doesn't probe the contents of his mind, and because he doesn't actually concede anything by just putting his finger on a piece of glass or whatever it may be, that doesn't have the same testimonial qualities that being asked to produce something that's only contained in his mind would. There are some implicit testimonial qualities to the mere fact that he could unlock the phone, and those might be subject to the foregone conclusion. But that would stray far from the actual facts that the court is presented with in this case, where inescapably what the court is telling the defendant, or the trial court was telling the defendant you have to do, is tell the state the passcode that's contained in your mind.
But doesn't your whole, your whole bigger picture argument hinges though on the idea that, and I don't agree with you on this actually, but the idea that you don't just focus on the communication that's inherent in unlocking the phone, but that you actually lump in everything that's on the phone too. And so if the prohibition is on, helping the government sort of prove its case against you because you're giving, you're essentially being made to be kind of, part of them gathering their evidence, everything that's on the phone and everything. Isn't that the problem with the thumb issue? Is that in the same way of, just revealing the passcode in some other way, that you're basically roping the defendant into actually the contents of the phone?
That's true. And in that respect, it may have implicit testimonial qualities. And in that respect, it may be a situation where the state needs to demonstrate a foregone conclusion exception has been met in order to compel the fingerprint. But to say that it is tantamount to testimony in the way that the trial court's order below is tantamount to testimony, I think there is a distinguishable difference. I think there's a difference between saying you're required to tell us something you have memorized versus you're required to just, in order, put all of your fingers on this phone until it either unlocks or never unlocks.
So then do you also think that there's a difference between revealing the code versus typing it in without the government knowing what you typed in?
Yes. Because in both of those cases, you're still asking the defendant to utilize the contents of his mind in order to unlock the phone. And in both cases, you're creating evidence where that could be used at trial, even if, hypothetically, the phone were subsequently searched and no relevant information were found in the phone. A witness who was in court that day, say the investigating officer who showed up for the motion to compel hearing, could come into court and say that on such and such date, the defendant was compelled to unlock the phone with his fingers. He was shown the phone and he typed in some numbers. I didn't see what numbers, but after the phone was handed back to law enforcement, the phone was unlocked, from which the jury would be free to infer that he had the passcode that was effective at the time that the phone was recovered from the crime scene, which then infers that he was the one in possession of the phone when it was left at the crime scene, making the state's case that he was the one who actually was at the alleged victim's new boyfriend's home and had smashed
Would-
the
would-
window.
Would there be some sense in sort of looking at this in a new way and bifurcating the way you analyze the issue based on the purpose for which the request is made? For example, even with like a key to a safe, I would think that if the government compelled someone to open the safe, they then, that act of opening the safe with their own key, they couldn't bring in an agent to say, well, we're going to prove that he had control over the safe because he got the key and it was his key and he unlocked it. And so that seems like it would be problematic if you look at the original intent and meaning of the Fifth Amendment, that compelled act. But conversely, if the government forces you to compel the passcode or anything else that requires mental process or anything else, of course that would mean that they couldn't use that information to prove control, but that's not the purpose. Why can't we look at it? Because I think Mr. D'Souza is correct that the Fifth Amendment was not intended to allow the privilege to be asserted in order to thwart the government's access to information that they had a lawful warrant to access. So it seems like there ought to be, does that make sense?
Yeah, but respectfully, respondent believes that conflates a Fourth Amendment issue with a Fifth Amendment issue. There's a difference between law enforcement having the ability, once it shows a magistrate or on-call judge that they have probable cause to acquire a search warrant and then go into a home, versus asking the defendant to participate in providing them with incriminating evidence that would further their search. So to say that it's obstructing them from performing the search is just the happenstance of this particular quirk to the development of this technology in the digital age. The reality is that encryption technology has to be defeated by decryption technology, which respondent believes that actually is available to the petitioner.
What about encryption without technology? I mean, you're forgiven for not briefing this because only Justice Muniz brought this to my attention, but Professor Kerr writes in the current issue of the Harvard Law Review about a letter written in cipher, right? And Chief Justice Marshall decides that it is not an act barred by the Fifth Amendment for a court to compel someone to admit that they know what the cipher is, what the code is, what secret letter is used to decode a communication. Would you still have the same arguments if it were an old school version of encryption? That is, I wrote this letter, it's in code, and I refuse to tell you what the code is to make sense of the words. All the same arguments apply?
I believe the same analysis applies. If it was a circumstance like Fisher, where there was a codex that converted the cipher to plain language that was previously created by the defendant, and potentially even held by another, perhaps whoever the message was being sent to, then that compelled production would be different because it doesn't require the defendant to probe the contents of his own mind in order to provide that information. If the order is compelling him to probe the contents of his mind and provide or create a codex that says this is how you decipher my cipher, and give plain meaning to the document that the state has that they think might contain incriminating evidence, then that would be the same analysis and would reach, we think, the same conclusion, which is that you're asking the defendant to become a witness against himself, regardless of whether or not that actually leads to information that you use at trial, because it raises the possibility that you don't know what's in the document, just as you don't know what is in the phone or what may come out of the statement that the defendant is invoking the Fifth to avoid revealing. You don't know yet what information might be involved. You don't know whether it's going to involve privileged information, whether it's going to involve information that relates to other crimes. And because of that specter of a new harm that cannot be remedied on direct appeal because it's already out of the bag, that creates the full violation, the total violation for the purposes of appellate review, for the purposes of seeking certiorari jurisdiction before Florida District Court.
I mean, it seems like your side is the one that's conflating the Fourth and the Fifth Amendment. I mean, it seems like sort of overbreadth and getting access to more on the phone than what the government really should be able to access for purposes of investigating this crime. It seems like that all of those things really should be dealt with as a Fourth Amendment issue and not sort of swept into this issue of giving the government access, just like, letting the government into your house and then what they're allowed to do once they're in there.
Well, except that the problem again is that if he is compelled to provide a passcode, assuming that he can, and assuming that the passcode works and unlocks the phone, that in and of itself provided evidence the state didn't previously have. At least that's our contention. The state doesn't.
At most, the ownership of the phone, which in this case, I know you're saying that it's disputed, but if this case were just about whether there was enough evidence to show that it was his phone, that's not why we're here. Let's assume the state has evidence that it is your client's phone, and it's really just a matter of unlocking it. Where does that leave us?
I think then the question still remains about what kind of testimony the state is asking the defendant to provide, whether it's an act of production or whether it's actually testimonial. So long as the order requires him to delve into the contents of his mind to provide the passcode, our position is that's still testimony.
Right, but then the foregone conclusion doctrine comes into play, right?
We only believe the foregone conclusion doctrine comes into play when we're dealing with an act of production, not with actual testimony. When the act of production may have testimonial qualities, then the state can demonstrate with that something is a foregone conclusion, that the phone is locked, that the defendant has the passcode to that phone to unlock it, and that the evidence that they're seeking behind the passcode wall, they can identify and they know to be there. That in the language of Fisher, that it exists and that it's authentic. That if they can demonstrate that those things are a foregone conclusion, we argue that beyond a reasonable doubt standard would be the appropriate one to protect such an essential right. Then the state would be able to do it, assuming that it no longer requires the defendant to probe into the contents of his mind.
Counsel, you are a couple of minutes over at this point, but we have helped you with that. So I'll give you another minute to sum up.
Thank you, Your Honor. Because the trial court's order compels the defendant to provide some statement that has not yet been entered, it is different from the situation where the defendant is coming to the court with a motion to suppress, trying to get the exclusionary rule to apply to suppress statements that have already come out through what's arguably a coercive interrogation, which are the cases that the state relies on to argue that there is no cognizable injury yet for the certiorari review. This circumstance creates the specter of harm that cannot be adequately remedied on direct appeal because you do not yet know the contents of the compelled testimony. And since the contents of the compelled testimony, just as in a civil case, may involve information that is privileged and may involve information that incriminates the defendant for crimes that he's not currently facing, he has a harm in complying with that order. Also because it creates this ultimatum of either comply with the order or face a new charge of contempt. In those circumstances, we believe that certiorari jurisdiction does properly lie, that the 5th District had proper certiorari jurisdiction to issue its order quashing the trial court's order. We believe that the trial court's order does compel actual testimony to which the foregone conclusion exception does not apply because it requires the defendant inescapably to use the contents of his mind to provide incriminating information against himself. For those reasons, we ask the court to affirm the 5th DCA's order. Thank you.
Thank you, counsel. Rebuttal.
Thank you. So I'll start again with irreparable injury. There have been some additional theories, I think, propounded by Mr. Garcia at oral argument, but in the briefs and below, he was quite clear about what he believed that his injuries were. And perhaps the clearest place you can find this would be page 5 of his reply in the district court. He said he would be harmed in 2 very specific ways. He said, number 1, if I'm required to turn over my passcode, law enforcement will be able to execute the search warrant, and they may find evidence that is damaging to me and can be used in the criminal prosecution to prove my guilt. Now, we know that the fruit of the poisonous tree doctrine would apply to all of that, and I think that takes that off the table. And then he said, number 2, my act of producing the passcode could be used against me to show that it was my phone. Again, however, if that were introduced at trial, which we don't intend to introduce against him, but even if that were introduced against him at trial, he would still have the same remedy that criminal defendants always have, which would be to simply take an appeal.
You're saying what's new is this idea that there could be things on the phone that are completely other criminal relevant stuff that has nothing to do with this.
So we think that
You're saying that's what you were alluding to with the new theory.
I think that's part of it. So certainly he has now cited the the civil discovery cases. That's not the theory that he pled in his petition, and he was very specific in his petition. So Judge Luck, concurring for the 3rd District, made what we think is a good point, which is that how can a district court assess irreparable injury based on injuries that the defendant himself has not asserted that he has suffered? So I think, number one, that perhaps clears up some of that. Number two, going to the merits, Justice Couriel, you referenced Professor Kerr's Decryption Originalism article. I think, of course, that article helps us, but our case is somewhat stronger still for 2 reasons. Number one, in the Aaron Burr trial, there was no warrant involved, so far as the transcripts in that case that I read revealed. So the fact that we do have a warrant suggests that we have a right of access. Number two, in that case, to decipher the documents would have been to effectively translate the documents from one language into another. And so the document itself that was evidence was protected by a cipher. All we're saying is that we need to get past a door. That door is encrypted, but it's not as though once we get past the door, we'll need him to translate the documents for us. So I do think this is a somewhat easier case. I'd like to answer any additional questions that the court may have, but I have nothing further to add at this point.
We thank you both for your arguments in this case today. That is the last case on today's docket. The court will now be adjourned.
All right.